I'm Nadia Gurwell.
I'm John Goliatino.
I'm Michelle Blanchard. Welcome to 30 Minutes. Welcome to 30 Minutes. I am your host, Michelle Blanchard. My guests today are two divorce attorneys with the law firm of Collins Hannafin PC in Danbury, Connecticut. Please welcome attorney Eva DeFranco and the one and only Bobby O. Robert Opotzner.
Hi, how are you?
Eva,
Hi.
I have to first apologize for not giving you a grand introduction like I did Bob, but that was a specific request.
Quite all right.
So before we get started on our discussion today on traditional divorce and mediated divorce or mediation, let's take a few moments to tell the audience a little bit about yourself.
Sure. So I've been practicing primarily divorce law in Danbury, Connecticut for about 31 years. I transitioned my practice about 10 years ago from primarily divorce litigation to mediation.
Mm-hmm.
And I primarily practice in the divorce mediation realm right now.
Right. And Bob?
I've been practicing law for 39 years. I do divorce litigation, both the traditional model and collaborative divorce.
Mm-hmm.
I'm a special master, as is Eva, in the court system, and I'm here today to try to help educate people about the divorce process.
Okay, great. So Bob, let's start with you because you focus more on traditional divorce. Let's set aside collaborative for the moment.
Sure, yes I do.
So can you just talk basically, and we'll go into more depth in a little bit, about the traditional model?
Sure. The traditional model is that in order to get yourself divorced in Connecticut, you have to be in court literally twice. Once when the court case starts through the divorce process, and once when the case ends up. And how you get to the end process, there are different options. But the traditional model is people hire a lawyer for each side, and the lawyers attempt to work with the people to help them reach a resolution. About 90 to 95% of all cases settle without having a full trial.
Okay.
And in that interim process from the divorce is started to when it concludes, the goal is to define what the marital assets are, define what the issues are in terms of finances, children if there are children involved, and try to work out a resolution. If you can't work out a resolution, then at some point in time there will be a divorce resolution by a court.
Okay.
And you'll have a judge who will make the decision after hearing evidence from both sides, and that's the traditional model of how one gets divorced in Connecticut under the laws of the statutes of our state. And I should mention that every state has its own requirements for the divorce process. So if you say, I had a client yesterday say to me, well, in Massachusetts, X, Y, and Z would happen in alimony. I said, well, that's very nice, but your case is one in Connecticut. So the Connecticut laws are relatively unique, although there are some commonalities, there are some uniform acts federally, but basically Connecticut laws apply to Connecticut divorces.
Okay. And what would you say the time frame is for somebody in the traditional process from start to finish on average?
Sure. Well, the traditional model requires a 90-day so-called cooling off period. So approximately a 90-day period of time between filing the papers and when you have a certain thing called the return date. The case management date is when you have a time to work things out if you can. But if the case is not resolved, the rule usually is a year or less. If there's a custody battle, it could go a little bit more, but the goal is state mandates it to try to do it within 1 year process.
Okay.
It varies widely from case to case
Absolutely.
as well. I mean,
Yes.
it depends on a lot of things like how motivated the lawyers are to resolve it. There could be strategic reasons for each party to want to wait for a little bit. So it really is a case-by-case thing. And I agree with Bob, it's about a year. You know, when people ask us that, we usually say a year because it doesn't go longer. But there are many subjective issues that go into how long a specific case actually takes.
Right.
And interestingly, now that we're in December of 2017, forgetting aside now the fact there may be some tax law changes coming up, but aside from that, if people are divorced in 2017, they can't file as joint filing status.
Right.
So sometimes we'll have an agreement in place right now and say, let's wait until January to get the divorce judgment done so people get the benefit of a better filing status.
Right.
So that's why things can be shifted not just by the parties, not by the court, but also by the tax laws.
Right, absolutely. Eva, let's talk about the mediation process.
Okay,
basic
so
overview.
in my mind, mediation is a vastly different process than
Absolutely.
the traditional divorce method. When I began practicing, there was no discussion about how folks wanted to get divorced. You know,
They were just really seared to the traditional method.
absolutely. And now, you know, and most of us would agree that we're compelled to explain people, prospective clients, the varying processes that are available to them. Mediation is really geared toward a settlement. The traditional model is not necessarily geared toward a settlement. In mediation, the parties are together, and the process is a team approach to understanding all the substantive issues that need to be resolved, gathering all the information to allow the parties to make an intelligent decision.
Right, to share the information, is that?
One of the hallmarks of mediation is that there has to be this transparency,
Right.
Where each party shares everything. Everything is on the table. But the process involves the mediator essentially guiding the parties in a safe environment to discuss the substantive issues that they need to resolve, to facilitate the conversation in a reasonable manner, to help them propose options and help them weigh the advantages and the disadvantages of each option.
Right.
And, you know, use the craft of mediation to help them get to a comprehensive resolution that they understand and have made themselves.
Right. The mediator, you for example, you're working for both parties, correct? So you're
Yes.
working in the best interest of both parties.
Yes, the important distinction, or one of the important distinctions between a traditional approach and a mediated approach, is that the mediator doesn't represent either party.
Right.
The mediator is hired as a neutral. And therefore there's a limit and a line beyond which a mediator, in best practices terms, should not go in terms of giving either party legal advice. So one of the preferred models for experienced mediators is that you have the mediator, you have each party, and then each party below that has their own private counsel that they can go to, pay an hourly rate, and get specific advice to help support them through the mediation.
Right. And are you seeing a big movement towards mediation from the traditional model?
I think yes,
Okay.
definitely. I think when I began mediation, 10, 12 years ago, mediation has been popular for a long time. Different states have embraced it at different times, and the trajectory is absolutely, it's a model that more and more people are using.
And I would agree that there is a trend in our society, especially in Connecticut now, of what we call alternative dispute resolution, ADR. And people are more and more choosing mediation, collaborative, some are going self-represented. So there is a movement away from the traditional model, but you still have a situation where people sometimes can't, in every
Right.
case, can't be mediated.
Right.
There's also a side thing, and that is, although I don't do traditional mediation that Eva does with two parties and herself, I do mediation where other lawyers will hire me periodically, happens to think Eva as well, where we'll try, if there's, let's suppose the lawyers in a case can't resolve their matter, and let's suppose they have, out of 20 issues, they resolved all but 3. Sometimes the lawyers and their parties will come to our office, they'll hire me as the mediator to say, okay, Bob, we have 3 different issues here, present their matters to me, and maybe in 3 or 4 hours we can help them reach a resolution on those issues. So it's a different kind of mediation. And the whole goal, of course, is people should not be spending. And as a lawyer, maybe I'm saying something that's an anathema to some lawyers, but we as lawyers, I know Eva doesn't and I don't, we don't want people spending or wasting money on a divorce case that can be used better for the children.
Absolutely.
And so when people get down to 3 or 4 issues, why go to court for 2 or 3 days on 3 or 4 issues? Because it's, quote, principle, unquote. So that alternative mediation arrangement can be used to try to bifurcate that.
Right.
And second of all, when you have a traditional case, In Danbury, and in many of the courts in Connecticut, we have what they call the Special Masters Program.
I was
which
going to ask you about that, yes.
both Eva and I are Special
Okay.
Masters, experienced lawyers. It's usually a male-female team. And the parties and their lawyers will meet with the mediators. We have an especially good process in Danbury, and we'll spend an hour or more with people hearing from their lawyers the key issues to try to, again, we do it voluntarily, Eva and I, for example, and we help them try to reach a resolution, and if they do, that's great. If they don't, the court will then perhaps assign a court date. Danbury is unique because a lot of the judicial districts in Danbury only have the attorneys and the special masters present. In Danbury, we have the parties there also, and we have probably a double settlement rate or more because the parties there. It's a great system.
Oh, that's great.
Yeah, I mean, most attorneys do take settlement, particularly in divorce matters, very seriously.
Right.
And work from the beginning to settle cases. And I'm glad Bob said that because, you know, there are, other than financial costs to having an extremely bitter or adversarial divorce. And, you know, people do say you can have a good divorce, you can have a bad divorce, but the costs in terms of how the children experience a divorce are irrevocable.
Absolutely.
And there are empirical studies that show that at the end of the day, how parents get divorced carries lifelong effects on children.
Right, they're so impressionable at that age.
There's also the stress level involved in being in an adversarial situation within a family that you can't discount.
Right.
And even how the divorce starts, the lawyers can have a very important role in setting the tenor of the process. Sometimes we'll have a client say to us, when we file our papers, and the papers that you file to start a divorce are called a complaint. And if you took 20 lawyers in the Danbury area, the complaints would be for 18 of those people, 90% almost identical, establishing jurisdiction, those kinds of things. But once in a while, you'll see someone put a claim of what the fault of the marriage is. The kids can see that because records are
Public.
open, except for
Public,
federal
yeah.
financial records are not open if the parties settle. But if you say mom did this or dad did that, it sets a very bad tone. And we as lawyers can help people not set a bad tone. And you know, if the kids are 7 or 8 years old now, in 15 years, when they're 23 years old, for example, they want to see what the papers say, it's important. So that's why a resolution is really the best way to go. And whether you go mediation, collaborative, or traditional, that's our goal to
Right.
resolve.
So is it fair to say that mediation on average is cheaper than the traditional model?
Yes, I would say in a general sense, but
Okay.
you know, it's a very fact-specific question.
Case by
You
case,
know,
yeah.
case by case. I mean, I've had, you know, people come to me and from start to finish, you know, we've had 3 meetings, okay? And then I've had people with perhaps more complicated financial issues, perhaps the necessity of bringing in experts like you into the mix to talk about stock options or business valuations that need much more time.
Right.
But because in a mediation process, things tend to be streamlined, and you're essentially dealing with one neutral and not 2 separate attorneys throughout the process, it tends to be cost effective. But again, case by case.
Right.
Let me support one thing you just said. If people are choosing between the traditional model and let's say collaborative or mediation, but they're not sure, they could go to a short calendar, which is the Monday session we have
The
in
amount of
court.
times I've heard you say that.
Because it's true.
I'm going to show up there one day, Bob.
Yeah, I think, because what happens is if you have an argument that's a short argument, you could be there all day
Right.
waiting for the court to hear you. And
you're paying the attorney to be there as well.
Right. That's why we do advocate
Right.
trying to resolve it no matter what model you're using.
Right. So I'm kind of jumping ahead here because I want to kind of circle back to 2 topics that I really think are the meat of going through a divorce. But Eva, because you are focusing on mediation, kind of walk me through the process that you have with a potential client to kind of overlay the mediation process and to determine if it's a good fit for them.
So you're talking about screening for suitability?
Yes,
Okay.
exactly.
So,
Thank you.
well, you know, what I start with is an introductory meeting with the potential parties. And I can get a lot of information at that introductory meeting.
Right.
Okay. So that meeting is billed as explaining the mediation process, but it's very. I ask a lot of questions. Most cases are suitable for mediation, even if the parties don't get along, and even if there's a level of mistrust.
What do you mean by suitable? Just to kind of define
As
that
Bob
a little
indicated
more.
before, I would say not every case can be mediated.
Right.
Okay.
Right. They're
There-
just really not there mentally, emotionally to work together.
Or there are power imbalances that would preclude that process as the best process to protect each party and come out with a good agreement.
Right.
Okay. I thought that's what you were asking.
In a roundabout way, yes.
But generally, I have the parties in and I tell them about mediation, and if there are red flags to consider, they come up in that first meeting and we'll talk them through.
Okay.
Even when people come to see me, some people are relatively sophisticated and will say, hey, I want to talk about mediation, I want to talk about collaborative,
Right.
but some don't. And when I get someone for my first meeting, the consultation for the first meeting is about an hour to hour and 15 minutes, and I will tell people in advance what they should bring. And the things I ask for are things related to the statutory criteria of alimony and property and children, that kind of thing. And I have my little folder that I give to my clients from day one, and I'll pull out statutes that don't apply to them. But in that process, I will get to the point, like I said at the start of this discussion, of telling you how you get divorced, and I will have discussions about alternative dispute resolution, mediation and collaborative, and I will try to recommend to people, if I think it's appropriate, even though I don't do the pure mediation like Eva does, since I do collaborative, or I can refer to mediators, I want to see what can happen. If people have a certain situation where they're both sophisticated, for example, and they both have good working knowledge, and they have equality pretty much, and they're just resolving a few different issues, that's ripe really well for a mediation process, for example. And I'm not going to, if someone comes to see me, say, well, I don't want to recommend mediation because I don't do that.
Oh, absolutely.
We delegate out and
Yeah.
recommend to people,
Right.
and I think that's what makes our firm well known and good at what we do, because we can direct people to things that if we don't do it, others might in the firm do that.
Right.
Or
So
elsewhere.
I just want to circle back because we've mentioned collaborative a few times, and we have done a couple of shows with John in the past on collaborative process. But for the viewers who may not know what collaborative means, can one of you kind of just give a basic overview of the collaborative so that they know?
Do you want to
Sure,
leave it? Go
sure.
ahead.
So the collaborative is, the process looks like each party has his or her own attorney. That part of that attorney's job is to give specific legal advice to the party, but all of the meetings take place in a four-way conference room, and it is a streamlined process designed to be a problem-solving team approach to resolve in a rational, reasonable way all of the substantive issues that need to go into the comprehensive divorce agreement. So the focus is on settling. Discovery is generally streamlined. Parties and the attorneys sign an agreement indicating that they are not going to go to court,
Right.
that they are going to resolve things together in a facilitative way.
Right. So when you talk about team approach, in addition to the two attorneys, you have mental health professionals who are there to work with the parties to deal with some issues that may come up. And then you also have a financial person who helps walk through the process with the clients to really determine the financial aspects of the divorce process.
Each case has a little bit different. That's the traditional model.
Exactly, yes.
In fact, I have a case right now in which you're a financial planner in a case that we
Yes.
have. But people sometimes get intimidated by the collaborative process because when we start telling people that you might have different experts involved, they say, oh my God, ka-ching, ka-ching, it's going to be more
Right,
expensive.
it's a little complicated. Not
But what-
complicated, but
Right,
could
and-
be construed that way.
But what happens is you start off with a meeting with the two lawyers and the two parties, and you discuss things, and I like to do goals. The first meeting is goals. What are your goals and what are your objectives? And by hearing what's going on, you can help frame issues and discuss what needs to be discussed. I had a case that went collaborative in which we did have a successful collaborative model, and one of the parties had serious medical problems, so we brought in a trust and estates lawyer to help us define those issues. Instead of having both lawyers hire their own trust and estates attorney, we brought someone who explained in a neutral perspective what's going on. You still have your own lawyer. The laws still apply, the same rules apply in terms of the ultimate outcome, but the way you get there is a much more collegial approach to the process. And so there are ways that it works. And in some cases, you do have the expert who's the mental health professional. And sometimes the lawyers will say, you know what, people, you're better off having so-and-so help you resolve the issues, a family health expert, psychologist, social,
It is an
whatever.
emotional process.
Yeah, and sometimes getting the lawyers out of the room is not a bad idea.
Right.
The inclusion of a mental health professional, even in mediation, because there is a co-mediation model where you have a mental health professional and an attorney co-mediating. But whether collaborative or mediation, the inclusion of a mental health professional adds a level of productivity to the meetings that you wouldn't otherwise get. And secondly, and even more importantly, the parties experience the process differently. If there's a mental health professional guiding the discussion and caring for the emotional needs of each of the parties, which lawyers are not great at, right?
And there is also a screening
true.
process for collaborative as well. I had one case that started out collaborative but didn't finish collaborative. When we went through our goals, we asked one of the parties, we said, what is your goal? And the party said, I want all the assets. And I looked at the person who asked the question, I said, well, you want all the assets? Well, is that really a fair goal? Give me a reasonable goal. She said, I want reasonably all the assets. And we finally decided that that might not be a case in which collaborative would be successful.
Right, right. Okay, let's kind of circle back to the traditional versus mediation
Sure.
process and talk about two topics that I think are the heart of it. And correct me if I'm wrong, because I'm looking at it more from a financial standpoint. Let's talk about property distribution. Is there a specific statute that applies to property settlement?
Yes.
Okay.
Okay, and there are statutes on alimony and property.
Yes.
And we should note that today's taping is December 1, 2017, because
tree.
because by the time we hear this tape, the law may change on the alimony side. But
Right.
I'll give you
Right, we're
where
waiting.
it stands today.
Yeah. And that would be a great, just to interrupt for a moment, that would be a great follow-up show
We'd
to
be happy
really
to come
talk
back for
about
that, yeah.
that, because that could be a huge,
Factor.
yes.
Huge change.
Yes,
But
absolutely.
the change they're going to make would likely be divorces going forward. Now, whether it's going to be divorces
So it
that
would
are
be retroactive to 2017.
right, it would probably be unconstitutional to do that, but it's likely to go forward. But anyway, speaking of where we are now, there is a statute that talks about property distribution in Connecticut. We are an equitable distribution state. And one of the things we do in the divorce process is define what are the marital assets. And so that's often an important part of things. And once you know what those assets are, then you talk about how do we want to recommend or argue for or advocate for allocating assets in the situation. There's the asset issue and alimony, though, are together. We call it in Connecticut a carefully crafted mosaic
Okay.
from a case called the Swami case, I think from years and years ago. So it's all part of a picture together, but that's what you do. And it doesn't matter, by the way, whose name the asset is in. If the asset were in your name totally, it doesn't mean that the court couldn't say, wait a minute, you're going to share that with your husband, for example, in a divorce process.
Right.
So that's the statute that does exist on property. And finally, if you make a property distribution at the time of the divorce, it cannot be, under the law right now, changed.
Okay.
Whether you want to modify it, there's other issues down the road on that, but typically speaking, right now, you can't change a property, whereas alimony is different.
Okay.
The equitable distribution statute in Connecticut leaves a lot of room to negotiate, because it's not, as Bob indicated, we're an equitable distribution state. That's distinguished from a community property state where things are a little more sure. You know, there's a statute that says everything's going to be divvied up 50-50 except for premarital assets and post.
Right.
In our situation, there are basic judicial norms that most of us can count on and advise our clients about, but there is room, you know, to negotiate.
To negotiate.
And also, there's a lot of factors. One important factor in property is who was involved in the acquisition of the assets, for example.
Okay.
But Eva said it's gray, because I've had cases where someone brought a lot of money to the marriage, but they didn't necessarily get all the money back because of all the different, there's about 15 different factors the court considers in equitable distribution of assets.
Right. We are running out of time. We have like 3 minutes left. So I just want to briefly touch on alimony, and I think we definitely should have another show to kind of cover. I have pages of questions that I just want to make sure that we cover. But let's circle back to alimony. That is a question that I get a lot.
Well, alimony right now is determined in a certain way with various factors, the length of the marriage, the cause of the breakdown, the earnings of the parties. I think a very common theme we have is one party, not necessarily the husband or the wife, but one party is working as the, quote, breadwinner, and the other party has been at home raising the children more traditionally. And it could be either spouse more and more nowadays. And so the courts look at that and don't say, well, wait a minute, husband, you've made $100,000 a year for 10 years, for example, it's $1 million, and wife, you've only made $50,000 in those 10 years. The courts consider equitably all the contributions. In fact, I have a list of 4 or 5 cases. Whenever I hear that argument from a person, if I have a client in a consultation, well, she should get alimony, she didn't work. I'll pull some cases out and say, wait a minute. Here's where it says a homemaker is a viable thing. So that's an important factor to consider, is what's the overall situation? Because the courts, the law doesn't want to have one party post-divorce live in a beautiful home with everything you could want, another one have a one room who knows what where.
Right, right.
Just, I know we're out of time,
No,
but
that's
in
okay.
mediation, the focus, you know, for example, is more budgetary. Not what a court would do with this given set of circumstances, but how, for example, do we make this work with the 2 incomes and the 2 sets of expenses?
Right, right. And that's where I kind of come into play and have helped you from time to time.
Exactly.
Is really look at different scenarios from a tax standpoint. Who's better off taking the deductions? Who's better off filing certain statuses? So.
Thank you for inviting us here. It's been very
Thank you.
educational.
Thank you for coming.
Yeah, really appreciate it.
No problem. Do you want to, one of you, give out the website? If the viewers
Eva can do
want
that.
to contact you, they know how to get
The
in touch with you?
website is CH Law, right?
Yes.
CHlaw.com?
CHlaw-CT.com, I'm sorry.
Okay, why don't we say that again?
CHlaw-CT.com.
Okay, and your phone number?
203-744-2150.
Okay. Well, thank you for joining us on this episode of 30 Minutes, and I look forward to meeting up with you again. Thank you. Thanks for showing up.